Welcome, everybody. Thanks. We're going to get started. Good evening, and welcome to the celebration of Andrew Manuel Crespo and his appointment as the Morris Wasserstein Public Interest Professor of Law at Harvard Law School. It's fabulous that all of you could come join us. We have standing room only, which is fitting. Let's please give a special welcome to Andrew's partner, Abby, and his mom, Sandy, who are both here today. Welcome. Also with us by popular demand is Interim Provost John Manning. Welcome back. Before we hear from Professor Crespo, I'd like to share a little information about the professorship itself and then say a few words about our honoree. The Wasserstein Chair is named after the late Morris Wasserstein, which is a surname that you will recognize since we are in the Wasserstein building. Morris emigrated to America from Poland in the late 1920s. He and his wife Lois, also a Jewish immigrant from Poland, raised 5 children. One of them, Bruce, graduated from Harvard Law School in 1970. We are extremely fortunate that Bruce and the Wasserstein family has on many occasions generously supported vital public interest initiatives here at the law school. The Morris Wasserstein Public Interest Law Professorship, established in 1995, commemorates Morris's and the entire Wasserstein family's belief in service to others. It aims not only to support the brilliant legal scholars who hold it, but also the students whom they train and who become leaders in public interest law themselves. Fittingly, at its inception, the chair was awarded to Elizabeth Bartholet, the extraordinary civil rights and family law scholar who founded and directed our child advocacy program and who held the chair until her retirement in 2021. Unfortunately, members of the Wasserstein family are not able to join us today, but we owe them enormous thanks for all they have done for our community. Please join me in acknowledging their many generous contributions. And now, Professor Crespo. Andrew Manuel Crespo joined the faculty in 2015. He came here with a remarkable pedigree, as some people say. He's a 2005 Harvard College grad and a 2008 magna cum laude HLS graduate, where he served as president of the Harvard Law Review, the first Latino to hold that position. Following law school, he clerked for 3 prominent federal judges: Stephen Reinhart of the U.S. Court of Appeals for the Ninth Circuit, Associate Supreme Court Justice Elena Kagan, and Associate Supreme Court Justice Stephen Breyer, who I'm pleased to say has also joined us today. Following his time as a public defender, Andrew served as an attorney with the District of Columbia Public Defender Service, where he represented more than 100 adults and juveniles charged with serious felonies. As many of you know, Andrew's research and scholarship center on the institutional design, legal frameworks, and power structures of the American criminal justice system, and on the relationship between lawyers, organizers, and social movement actors in effecting transformational change. His scholarship on these topics has appeared in all of the leading law journals. He has been honored by the Association of American Law Schools and has been profiled in the New York Times. Together with John Rappaport, Andrew is also the author of Criminal Law and the American Penal System, an innovative casebook that reorients the required 1L criminal law course around the problem of mass incarceration. Through his leadership, with Premal Daria, also here, of the Institute to End Mass Incarceration, Andrew works to integrate lawyers effectively and responsibly into anti-carceral campaigns and movements. Relatedly, he serves with Premal as editor-in-chief of Inquest, a forum for the exchange of ideas among scholars, journalists, community organizers, and others on ending mass incarceration. He is also chair of the board of directors of the Leading Change Network, an international nonprofit dedicated to supporting community organizers working to build more just and democratic societies around the globe. I could go on, but I will not. But I will say a couple of words about parts of Andrew's life that may be a little less visible than the ones I've just mentioned. It's important to know that back in high school, in addition to being valedictorian, he was a starting lineman on the high school football team, as well as being active in musical theater, a very rare combination empirically. As a Harvard undergrad, he continued to demonstrate his musical talents as a member of the Veritones, Harvard's a cappella group. Maybe he'll sing for us in a minute. And now, of course, he and his amazing partner, Abby, are parents to two lovely children. Speaking on a more personal note, it has truly been my pleasure and privilege to have worked closely with Andrew since he first joined the faculty. As his students will attest, he is an extraordinarily gifted teacher. In the terrible first few months of the COVID pandemic, when HLS had to pivot on a dime to remote instruction, Andrew was among a handful of faculty who helped lead the way, both by developing innovative methods of online teaching and, most importantly, by patiently, very patiently, sharing his insights with some of his less technology-adept colleagues. At an early stage of career, Andrew has also taken on the sort of invisible work that is absolutely essential for any great law school to thrive. I have seen firsthand, for example, the time, thought, and care he has put into the vital task of advising and mentoring junior colleagues. So, to sum up, Andrew is a brilliant scholar, a gifted instructor and mentor, a passionate advocate for justice, and a generous colleague and friend to those of us at Harvard Law School and well beyond. I can think of few, if any, people more deserving of being recognized with a professorship dedicated to public interest law, and I could not be more delighted to introduce him today. With that, please join me in welcoming Andrew Manuel Crespo, Morris Wasserstein Public Interest Professor of Law at Harvard Law School.
John, thank you so much, everyone, for being here. And John, thank you for that wonderful introduction. One of the real delights about coming back to teach at a place where you were a student is you get to call some of your former teachers colleagues. And my first time interviewing for a job here was in a small basement room in Areta that about 7 years before that had been my seminar room in a class taught by John Goldberg on law, retaliation, and justice. And I think we've had countless conversations about law and justice since I've rejoined the faculty. You have been such a tremendous mentor, and I can't thank you enough for that, and for stepping up to lead our school in this time of transition. When I graduated from here in 2008, I thought it was really cool that our class, I think I've got this right, I'm not a historian, but I'm pretty sure this is true, was the first class at Harvard Law School to ever have its diplomas signed by two women I really admire. Then President Drew Gilpin Faust, and then Dean Elena Kagan. And this will sound strange, but I had this sort of weird, like, oh, another historical moment. When I got the invitation to this chair lecture and saw it all sent around, I thought, this has got to be the first time there's a chair lecture at Harvard Law School that is signed and hosted by not one, but two deans named John. John Manning, in the 9 years that I have been figuring out and growing into the role of being a law professor and a teacher, I could not think of a better friend or mentor or leader for this school. When you and I first met each other after my job talk here, you told me that you thought I was a secret admin scholar. And I now know that those were the most loving words of welcome that you could have offered someone, and I have felt so welcome here every day since, in such a large part because of you. And thank you also for all the work that you're doing to lead not just our school, but now our university in all of these challenging times. There is one other dean who I need to thank, who unfortunately is not here tonight, but is more so than anybody else the reason that I am. As Martha Minow could tell you, I did not set out to be a law professor. In fact, if you'd asked me when I was a third-year student here what I might want to do with my life, I didn't know, but I would have told you a bit, I don't know, hubristically, that I was sure I did not want to be a law professor. It's strange to say this now, but at the time then at least, I thought law professors were aloof and detached from the real world, and I wanted to be in the real world. I wanted to be a real lawyer. In fact, I wanted to be a public defender, which is what I went off and became. But Martha, in the early days of my time working as a public defender, sowed the seeds of an idea of coming back here to teach. And along with my closest mentor in law school and now dear, dear friend, Carol Steiger, she would come back and water that seed every so often. And when Martha and Carol would talk to me about the idea of being a law professor, they would say, you should really think about it for 3 reasons. They would say, first, it's a chance to think about the big issues in the world, the structural issues, the systemic issues that are impacting each of the people you're representing every day, and to think about them as structural questions. Second, Martha would say, you can try to build something, to do something about it. And third, she would say, you're going to meet the most amazing people. You're going to meet colleagues who inspire you, and you're going to meet students who inspire you even more. Those conversations changed the trajectory of my life, and Carol and Martha, I am so grateful to both of you for that. And especially grateful because, as it turns out, it was not a sales pitch. You couldn't have been more right about the students. I can't tell you how overwhelmed I am just looking out into this room and seeing students from Section 4, Section 7, Crim Pro, and of course, our IUMI clinic. I've been at this job for 9 years, and in that time have seen the amazing things that students do when they leave this school. And especially when I think of those of you in this room that I've gotten to know so well over the past couple of years, I know that the best is yet to come. Martha was also so right in talking about the colleagues that I would meet here. I couldn't ask for better colleagues. Daphna and Liz and Crystal, when I think of when we joined the faculty, the amazing people who we were joining into the group of and how much work they put into helping us grow here, and then the incredible people who have joined the faculty since then, I just feel so lucky every day that these are friends that I get to look forward to growing old with. Hopefully not already growing old with. It's a wonderful place to work. But there's one person who is more than a colleague in this work, but is a collaborator, a co-conspirator, a partner. You know, Martha was right too about this being a place where you can build something. And I feel lucky about that, and also feel really lucky that I get to do that with Premal Daria, who from the first day of when our institute was an idea up to today has been such a tremendous partner in building every day an institute that I know we're both so proud of, and that I feel really excited to get to share our work with folks tonight. Which I will do soon, but first, if you'll just indulge me in saying special thank you to 3 more people who are really very special to me. The first is a man who I met 20 years ago, half of my life, in a junior seminar at Harvard College on the theory and practice of organizing, taught by Marshall Gans. More than any other educational experience I've had in my life, that class shaped the way that I think about the world and my sense of purpose in it. And Marshall, I just feel so lucky that now we get to teach organizing here at Harvard Law School to students, and that our lives have stayed so intertwined. My partner and my wife, Abby. Abby, when you and I met each other 20 years ago and 3 blocks from here at the co-op party on Sacramento Street, I had no idea that we'd spend the rest of our lives together, and definitely had no idea it would be at Harvard. But I knew you could dance. And I feel like we've been dancing ever since, and for every minute and every beat of it, I just want to say thank you, and that I love you very much. And finally, standing in one of the world's best schools, in front of so many of my own former students, I need to thank my first and best teacher. My mom, Sandra Correa, was a public school teacher for 40 years, first in the South Bronx, and then in a small town in upstate New York. That town was almost entirely white in its demographics, except that it was also home to a migrant agricultural community. So every fall and spring, the classrooms would fill with these Latino and Latina boys and girls. And there was one teacher in the school who spoke their language as her own and knew something of their stories. My mom was a trailblazer professionally all through her life, just like her parents. My mom's mom stopped school in the 3rd grade. Her dad stopped in high school so that they could cross an ocean from Puerto Rico to New York, hoping to launch her into the career she had. She was the first in her college to graduate from college and to earn a master's degree. And she launched me right up here, the first Boricua kid to give a lecture like this here. Mami, te quiero mucho. Thank you so much. And take good notes for Alex and also for Dad. I'm kidding, Mom. Actually, they're recording the whole thing. The title of this lecture is Root and Branch, Lawyers, Movements, and the End of Mass Incarceration. And it draws on some strands of work that I've been engaged in for the past few years, including on a book that I'm writing with John Rappaport that the Dean mentioned, called Criminal Law in the American Penal System, on scholarship on plea bargaining and collective defense, and on the advocacy and teaching work that Premal and I do through the Institute to End Mass Incarceration. My hope and my goal is to do 3 things. First, I'd like to offer an account of what mass incarceration is, what those words mean to me, and why it so urgently needs to end. Second, I'd like to explore the role that lawyers have played in building this system and consider 2 different models for how they might work to do something against it. And finally, I'd like to make the case for one of those models, what I'll here call lawyering in service of organizing, and offer a suggestion about how our profession writ large should think about the relationship between lawyers and social movement actors. But first, the problem. Mass incarceration is a word, is a phrase that everyone in this room has heard and knows and used. But people use it in different ways. And so when I'm using it, I want to be clear about what I mean, because there are 3 distinct but interrelated features of mass incarceration to my mind. The first is that when we're talking about mass incarceration, we are talking about a system of unprecedented scale. The United States incarcerates more of its own people than any country in the history of the world. We have 5% of the world's population and 1/4 of its prison population. In per capita terms, we incarcerate more of our own people by orders of magnitude than other countries with similar socioeconomic profiles, as shown here by just showing you the other countries in the group of 7. In fact, to get even close to our rate of incarceration, you need to compare the United States to countries that our leaders typically criticize for massive human rights violations or as authoritarian regimes. This impact, I should note, is not limited to prisons and jails. There is a broad network of carceral control and supervision, known as probation and parole, whereby people are often either under house arrest, electronic monitoring, and regular carceral supervision, always under the threat of being sent back to prisons or jails. In fact, one of the largest sources of entry into prison or jail is people who are revoked from their probation or parole. When you take this enormous scale of people who are impacted by mass incarceration into account, it becomes clear that the ripple effects of the system are staggering. Today, right now, almost 2 million people are behind bars. 10 million people will be sent to a jail this year. When you think of just people who have spent time in a state or federal prison and have since been released, it's 5 million people in our society, 20 million who have ever been convicted of a felony, close to 80 million who have a criminal record. And when you think about their families, you think about their children, their parents, their siblings, their loved ones. You have a phenomenon so massive in scale that it's touched close to half of the people in this country in a very direct and profound way. Numbers capture the scale of the problem, but I am always struck by this quote by an incarcerated writer named Arthur Longworth, who says, "Outside prison, mass incarceration is measured in numbers. But after more than 30 years in prison, my entire adult life, I have mass incarceration sewn into my flesh and bones. It buries me. It keeps me from breathing." I think of Mr. Longworth's essay when I think about my own clients. My oldest client was in his 80s and needed help to walk from the lockup behind the courtroom to counsel's table. My youngest client was 8. I met him on his 8th birthday. He was a kid, so small that his legs didn't touch the ground when he sat in the plastic chair in the jail cell in the courtroom. And yet, even though they didn't touch the ground, they were shackled together. He had an adult man's iron belly chain wrapped around him 3 times, and his hands handcuffed together and tied to this belly chain. And those images stick in my mind when I read Arthur Longworth's message, because in addition to a massive scale, it is a massive impact on real people, human lives, that is almost indescribable. The last thing to note about this massive scale is that it has happened in our lifetimes. After decades of being relatively stable, the American prison population started to increase in 1973 and then exploded across the 80s and 90s, climbing until 2009 when it reached its peak, at which point it started to slowly drift down. I emphasize slowly, insofar as if you just extended that rate of decline for the first few years from 2009 to 2017 and trailed them out, you'd get to 2091 before the prison population was half of its peak, at which point it would still be one of the largest prison populations in the world. But size is not the only issue. In fact, one of the most famous critical sociologists of the American penal system says we shouldn't really use the word mass incarceration. Louis Quoquant writes that the American penal system has been so finely targeted, first by class, second by race, and third by place, that it's not really mass incarceration, but rather the hyper-incarceration of sub-proletarian African-American men from the imploding ghetto. The racial disparities of mass incarceration are familiar to so many people in this room, and yet staggering to observe all the same. These are per capita incarceration rates broken down by racial groups, the number of people per 100,000 who are incarcerated as of 2021. And as you can see, Black people are incarcerated 5 times more frequently than white people, with Native Americans' rate of incarceration not so far behind. Latinos are incarcerated more than twice as frequently as white people. Take those 2 groups together, Blacks and Latinos, and you have the 1/3 of the US population, but nearly 2/3 of the incarcerated population. As for class, this figure has always jumped out at me. It's just showing income brackets for both incarcerated people and unincarcerated people. The orange being folks who are free in society. And that top bracket is folks who make more than $37,500 a year. This is data from 2004, when the median income was around $44,000. This is essentially showing you middle class and above. And in the free world, outside of prison, again, more than half of the country is in that middle income and above bracket. And what's so striking about this figure is you just look and you see it's exactly the reverse for people who are incarcerated. The vast majority of people in prison are poor, as captured by a much simpler statistic, the fact that 80% of them are represented by public defenders or appointed counsel because they're too poor to afford a lawyer. And then finally, there's place. This is a map of the city where I was born, New York City. And what is so striking about it is that it portrays the reality that in all of New York State, 42% of the incarcerated population comes from just 7 neighborhoods in New York City, including Harlem and the South Bronx, where my dad grew up and where my mom started teaching. This repeats itself in cities across the country. This is Chicago, where folks working with something called the $1 Million Blocks Project have mapped hyper-incarceration to the city block level, capturing individual city blocks where the state spends more than $1 million a year incarcerating people. Mass incarceration is finely targeted by race, by place, and by class. But the last thing that I think is important to know when defining the problem is that mass incarceration is not an accident. Michelle Alexander, who is probably the most famous public critic of mass incarceration, the author of a book I'm sure many of you know, The New Jim Crow, writes that mass incarceration is a massive system of racial and social control. Let's just pick that apart a bit and first take the racial part. As her title suggests, The New Jim Crow, Alexander's making an argument that mass incarceration is tied to a legacy of racial oppression. When I read her sentence, I think of our colleague Randy Kennedy's words, who reminds us that in many places, for several generations, it was a crime for Black people to learn to read, to flee enslavement, to defend themselves, their families, or their friends from physical abuse. It was a crime, in other words, for Black people to do all sorts of things deemed to be permissible and admirable when done by others. Randy, of course, is writing about slavery. Now, I remember learning about slavery and the Civil War in middle school and in high school. And I remember learning that slavery was abolished as a result of that war by the 13th Amendment. Neither slavery nor involuntary servitude shall exist within the United States or any place subject to their jurisdiction. Except, of course, that is not what the 13th Amendment says. The 13th Amendment says that neither slavery nor involuntary servitude shall be permitted except as punishment for crime whereof the party shall have been duly convicted. In other words, there's a fairly straightforward textual argument that the 13th Amendment did not abolish slavery, that what the 13th Amendment did was codify slavery, provided that, first, a person is convicted of a crime. This exception clause in the 13th Amendment was immediately put to use in the aftermath of the Civil War to create what historian David Blackman famously called slavery by another name. Where, beginning in the late 1860s and then accelerating at the end of Reconstruction, every Southern state enacted an array of interlocking laws intended to criminalize Black life. And it worked. Southern prisons turned Black overnight. Blackman recounts that by 1871, prisons in Virginia that had scarcely admitted a Black person prior to the Civil War, because of course, prior to the Civil War, Black people in Virginia were enslaved. By 1871, those prisons were 80% Black. By 1899 in Georgia, the prison population was 90% Black. This is what made it possible to see infamous pictures like this one from the Library of Congress captioned "Juvenile Convicts at Work in the Fields," which if you showed it to anyone in a sort of civics class and asked them what it depicted, they would probably tell you it depicts slavery, but for the recognizable prison uniforms that the children are wearing. This image to me has always been striking, both for what it captures, but also because it reminds me of this picture from 2015 of Angola State Penitentiary, the prison that has the largest percentage of people serving life without parole sentences in the world. A prison built on a former slave plantation. And where this picture was taken, that again, to me, evokes some unmistakable images: an armed overseer on horseback, looking at people who don't have any freedom and are tending the fields. Alexander also reminds us that mass incarceration is a system of social control. And here it's just to underscore the way that mass incarceration is tied into our economic system. Unemployment rates, massively higher in prison. Homeless rates, massively higher in prison. Structural failures in education, 62% of people in prison not having finished high school. Poverty, 4 out of 10 having been on public assistance. Intergenerational incarceration, homelessness. You take all of this together and it just underscores the point made by W.B. Du Bois over a century ago that crime is a phenomenon that stands not alone, but rather as a symptom of countless wrong social conditions. And when I see that written by Du Bois, I think we have to understand and read Michelle Alexander be saying, actually, no, it's that mass incarceration is a massive system of racial and social control, meaning racialized social control. Because if there's one thing we know about American history, it's that, as sociologist Elliot Curry puts the point, patterns of deliberate discrimination and disinvestment have profoundly shaped Black life, to the point that a century's worth of sociological research now shows that racial disparities in criminal offending are not symptoms of community failure. They're symptoms of social injustice, or what many of us would call systemic racism. That phrase, systemic racism, can sometimes sound diffuse. After all, the whole point of the phrase is to suggest that there is racism immanent in the actual structures of society. But I think it's important to also recall that there has been overt racism evident in some of the major policies driving mass incarceration. Consider, just as one example, the federal war on drugs. Drug offenses make up close to half of the federal prison population, which itself is the largest incarcerated population in the country. And that phrase, war on drugs, tends to be associated more than with anyone else with President Richard Nixon when he was campaigning for office in 1968, and argued that doubling the conviction rate in the country would do far more to cure crime in America than quadrupling the funds for the war on poverty. When he was in office, he urged and insisted that drug dealers should be hunted to the ends of the earth. Nixon's war on drugs shaped federal drug policy for the next 4 decades. Ronald Reagan multiplied by tenfold the amount of investment in federal drug enforcement. This continued on through Reagan's vice president when he became President George H.W. Bush, continued through the Clinton administration with the 94 crime bill, the 96 EDPA bill, continued through the George W. Bush administration, again until the prison population reached its peak in 2009, 4 decades after Nixon launched that phrase, war on drugs, into our national psyche. Which is why I am always struck when I read this interview with John Ehrlichman, decades later, who was the primary architect of Nixon's domestic policy, and who was asked about the 1968 campaign and what it was all about. And he responded, "You want to know what this was really about? The Nixon campaign in 1968 and the Nixon White House after that had 2 enemies, the anti-war left and black people. By getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, vilify them night after night on the evening news." Did we know we were lying about the drugs? Of course we did. Mass incarceration is a massive system of racial and social control, and I submit to you, it's not an accident. Which, for me, leads to a set of radically obvious ideas. And I want to pause here and just say a bit about this word radical. Because it's a word that tends to get both claimed by and wielded against people who are working to build anti-carceral futures. Those who wear the word as a badge of honor, and those who attempt to wield it as a weapon, sort of ironically, often use it to mean the same thing: extreme or far outside the mainstream. And I acknowledge that is an accepted meaning of the word. But when I'm using the word, I'm using it to mean something different. I'm using it the way the Oxford English Dictionary describes it, the way that Angela Davis describes it, when she reminds us that radical simply means grasping things at the root. Radical, in other words, means fundamental. And so when I'm talking about radically obvious ideas, I'm talking about ideas that are simultaneously obvious insofar as they are hard to deny, and radical insofar as accepting them would entail fundamental changes to the state of the world. Radically obvious ideas are essential to movements precisely because they help us capture the difference between the world as it is and the world as it ought to be. The idea that people should not be enslaved is both obvious and, in the 1860s, was radical because it required fundamentally reordering society and, in fact, caused a civil war. The idea that black people deserve equal dignity and flourishing is obvious and also radical, insofar as the civil rights movement had to itself again reorder American society, and insofar as that idea of equal dignity and flourishing remains a call to action for all who see that promise as unfulfilled. In the context of mass incarceration, given everything I've done to try to describe what that phrase means, I think it suggests, to me at least, 2 radically obvious ideas. First, it shouldn't exist. The United States shouldn't incarcerate more of its own people than any country in the world. The United States shouldn't continue a system of racial and social control with a genealogy tied to slavery. We should end mass incarceration. And second, if we understand it as not an accident, then I think we have to accept that ending mass incarceration requires more than just persuasion, more than just educating policymakers until the scales fall from their eyes. It requires power. It requires what Ben Sachs and Kate Andreas call countervailing power, which is concerned with the ability of mass membership organizations to equalize the political voice of citizens who lack political influence. Put more simply, countervailing power is the power of social movements. Which brings me back to the theme of the lecture, the relationship between lawyers and movements to the end of mass incarceration. And I want to talk first about the lawyers, because I'd like to suggest that there's 3 different ways of thinking about how our profession relates to mass incarceration. First, I want to suggest that we are uniquely part of the problem. And then I want to offer two different models of how lawyers might do something to fight back against it. But I want to start with the idea that lawyers have been uniquely part of the problem of constructing mass incarceration, because I think that entails the idea that there's a special obligation on us to do something about it. We have been constructors of mass incarceration in so many different ways. Think of legislation. At the beginning of the 1900s, the Federal Penal Code did not have mandatory minimum sentences. Fast forward 90 years, and mandatory minimum sentences, captured most sort of strikingly by these 3 strike laws, were spread across the entire country. As a result, prison sentence lengths exploded. In Florida, they more than doubled in that decade. This is especially significant because comparative scholars say that it's our sentence lengths that are the biggest thing that separates us from other countries. Today, 63% of people in prison are serving sentences longer than 10 years. Sentences that would be rare, if not unheard of, in so many other countries. And that number itself has tripled since 1999. Fueled in part by these laws, by legislation, by 3 strike statutes, by penal statutes, passed by legislators who are mostly lawyers. Throughout the prison boom, 40% of the people in Congress, representatives and senators, were lawyers. At the beginning of the prison boom, in our most populous state, California, almost half of the people in the legislature were lawyers. Midway through the most explosive decade, in the 1980s, in Virginia, more than almost half of the legislators were lawyers. Our profession passed the laws that fueled the explosion in prison sentence lengths. But of course, as we all know, legislation is not the only part of the story. We have a system of checks and balances, of separation of powers, which means that sometimes there's a judiciary that can check laws that are too severe or too punitive. And the judiciary is 100% lawyers. You might think that there was an invitation then for the judiciary to be a check on that legislation when you read something like the 8th Amendment, which seems to speak directly to punishments that are too severe, when it says that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. There is an invitation there to do something about sentences that are far too long, but this language has been essentially rendered a dead letter, again, by lawyers who wear robes. That's clear if you know the case of Leandro Andrade, a man who was a 9-year Army veteran, father of 3, and who in 1995 was arrested for stealing 5 videotapes worth a total of $84.70, and who, under the 3 strikes laws I was just describing, was sentenced to 50 years to life in prison, a de facto life sentence given his age at the time. If that sentence is not grossly disproportionate, the principle has no meaning, wrote Justice David Souter, dissenting in Andrade's case, trying to persuade the majority of the court that ruled the other way not to render the 8th Amendment a dead letter, an effort that was unsuccessful. All of which then brings me to the last way in which lawyers have driven mass incarceration. Because massively high sentences like Andrade's pave the way for a practice that I think is at the heart of where our prison system comes from. Because prosecutors are allowed to trade those excessively high sentences away for pleas of guilt. I've spent the lion's share of my time on this faculty writing about plea bargaining. I haven't counted them, but it feels like somewhere like, 100,000 words across articles, essays, book chapters. I will not recount all of that to you. Because all you need to know about plea bargaining in the United States, you can know from listening to the case of one man, whose name was Paul Lewis Hayes, and who was indicted for passing a forged check in the amount of $88.30. The prosecutors in his case told him that if he pled guilty, they would charge him under a statute that would expose him to in the neighborhood of 2 to 5 years in prison. If he did not plead guilty, if he insisted on his right to trial, they would instead charge him under a statute that held a mandatory life sentence. There's a famous essay about plea bargaining by a man named John Langbein, the title of which is Plea Bargaining as Torture. Langbein is a historian, and he was trying to make the argument that plea bargaining is not so different from the rack and screw. If you tell somebody, look, if you plead guilty, you'll get a $1 fine, but if you go to trial and get convicted, we will cut off both of your hands. All of us would recognize that as torture. All of us would say, gosh, that seems inconsistent with the due process of law. Langbain's point was that that is not all that different from telling someone, if you plead guilty, you'll face 2 years. If you don't and get convicted at trial, we will lock you up for the rest of your life. The Supreme Court again saw it differently. Justice Potter Stewart writing in Paul Lewis Hayes' case that the give and take of plea bargaining does not entail any such element of punishment or retaliation as long as the accused person has the option to accept or reject the prosecutor's offer. So long as the charges are supported by probable cause, the decision whether or not to prosecute and what charge to bring rests entirely in the prosecutor's discretion. The system this has wrought, according to so many different scholars who have studied it, renders a world which, as Rachel Barco puts it, turns prosecutors into the final adjudicators in criminal cases. And as John Pfaff has noted in his empirical study of the system, that prosecutorial power has been the primary driver of mass incarceration in the United States. In short, across all 3 branches of government, legislative, judicial, executive, lawyers have been some of the primary constructors of mass incarceration, which again, I think entails a special obligation to do something about it. But there are 2 pretty different ways of going about that. And for me, this is the part of the lecture that gets both the most personal and in some ways, I don't know, like a little uncomfortable and challenging. Because one of the ways to do that is by trying to be a mitigator of the harm, which is the work that I did as a public defender. I still remember the first time I ever saw this picture, which is the handwritten petition for certiorari, written from a prison cell by Clarence Earl Gideon to the US Supreme Court. I first saw this picture as an undergraduate here at the college in a class on the history of the Warren Court taught by Mort Horowitz. And even then, I remember feeling inspired by the case, the idea everyone should have the right to a lawyer. It wasn't until law school, though, that that inspiration was something that I felt more as a calling, in the almost religious sense of the word, calling to a vocation, in my first-year criminal law class, which was taught by one of the most famous public defenders in our country's history. My first-year criminal law professor, a man named Charles Ogletree. If you ever heard Tree talk about being a public defender, as he had been, it was hard not to feel called to that work. I remember sitting in his classroom and then sitting in his office, pictured behind him here, hearing him talk about what public defense meant to him. He had written about it in a famous Harvard Law Review article, where he said for him it came down to 2 things. Public defense was about empathy, and it was about heroism. When he talked about the heroism, it was stirring. I saw myself, he wrote, as a kind of hero of the oppressed, the one who fights against all odds, a sort of Robin Hood figure who can conquer what others cannot. But it was when he talked about the empathy that it would touch you right in your soul. I did not think about what my client had done, Tree said, nor did I feel responsible for what he might do if released. I knew only that at that moment, I was my client's only friend, and my friend wanted to go home. Still, today, when I read those things, I feel called. And also, if I'm being honest with myself, while I was practicing for all those years as a public defender, I also felt an uneasiness, a dissonance, that at the beginning was hard to place. Although if I'd really read Gideon maybe more closely, I would have seen at least some of the notes of the dissonance right there in the opinion. When the court, for example, explains that one of the reasons why the right to counsel is so important is to protect those who are innocent. Though he be not guilty, a person without a lawyer faces the danger of conviction because he does not know how to establish his innocence. When the court goes on to emphasize fairness in procedural terms, saying that fair trials before impartial tribunals would be threatened if you didn't have a lawyer to assist you. Nowhere in the opinion was there a concern over the question of whether the imprisonment itself was substantively unfair. In fact, quite to the contrary, the court wrote, governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime and incarcerate them. In other words, those discordant notes would play, and I would hear them saying something like, to safeguard innocence, you need a lawyer to assist you in navigating a properly vast machinery of incarceration, which, at least played that way, sounded like a less heroic song. No one has captured this point better than Paul Butler, who in an essay about Gideon writes, the reason that prisons are filled with poor people and that rich people rarely go to prison is not because the rich have better lawyers than the poor. In criminal cases, poor people lose most of the time because in American criminal justice, poor people are losers. Prison is designed for them. If this is true, if the criminal system is designed to punish poor people of color, then there's a real risk that lawyers who make its processes more fair are not just failing to address the core issue. There's a risk that I added a patina of legitimacy to that system of oppression. I want to be clear that this requires us to hold a real tension in our minds and in our hearts. As Premal writes in her own essay about Gideon, there is no question that having good, resourced counsel has deeply positive effects on the lives of the people ensnared in the criminal legal system. There is critical value to that work. Butler himself says he wants to make sure people reading the essay don't get the wrong message. You should still go become a criminal defense attorney, he writes. And at the same time, he wants to really emphasize that Gideon is a narrative about individual rights rather than a plea for class-based or race-based relief, and that this will not solve the problem. I felt this as I was practicing. As I've written, when I was a lawyer, I sat there in plea negotiation after plea negotiation and knew I could calculate the sentencing ranges for my clients. I could give them good advice about the pros and cons of their different options. But my clients needed more than information and advice. What they needed was the power to fight back. And they weren't going to get that from me as their lawyer. And as I continued to feel that practicing, that dissonance was there, that buzzing kind of in your head. Not just from the notes of Gideon B. Wainwright, which I hadn't read as carefully as I should have, but from reading that I had done, probably 15 years earlier at that point, that really stuck in my head in my junior seminar on the theory and practice of organizing that Marshall taught. Because as I remember it, at least, Marshall, one of the first readings on the syllabus is this essay with a title that always rang in my ears, especially while I was practicing as a public defender. An essay by a man named John McKnight, the title of which is Services Are Bad for People. Now, that is a discordant title if you work in legal services as a public defender. But part of what McKnight was trying to convey is the idea that there's a difference between giving people expertise as a professional service provider and helping people figure out how to generate power on their own. Really powerful citizens, McKnight wrote, make power by coming together, and they take power by acting together. Service systems act on the premise that professionals have the expertise and clients have problems that the professional can solve. An organizer, by contrast, tells the people that they have problem-solving abilities of their own and that they can change their community. Or, as Marshall so often puts it, organized communities learn to strategize about how they can turn the resources they have into the power they need to get the change they want. They do, in other words, movement work. And over the span of the last century, time and again, that work has been the essential ingredient in forcing fundamental, radical change. From the women's suffrage movement, to the civil rights movement, to the labor movement, to today. I joined this faculty in January of 2015, a few months after the Ferguson uprisings, and have been on it ever since. And during that time, the Black Lives Matter movement has arguably become the largest social movement in US history. It's a movement with many aims and goals, but as Professor Amna Akbar writes, It's a movement intensely concerned with systemic racism in the carceral system. And as such, it draws forward ideas and draws inspiration from ideas from half a century ago. It puts at its center a struggle to abolish the prison system in its present form, as part of a struggle against all dimensions of racism. Distilled and simplified, it's a movement trying to do two basic things. In the words of Erica Miners, Rachel Herzing, and Nuri Nusrat, it's trying to shrink as much as possible the size, scope, and power of the carceral state. And, to quote Dan Berger, Mariam Kaba, and David Stein, it's concerned with creating conditions that improve people's health, safety, and security. In other words, it's trying to reduce harm and build responses to harm that don't rely on imprisonment, surveillance, or policing. Which I think then again brings back the question, how could lawyers help with that? And I'd like to suggest that there's an alternative to working as harm mitigators, a model that borrows a phrase from Jennifer Gordon, who calls it lawyering in service of organizing. For the better part of the past decade, trying to understand how this model might work in the struggle to end mass incarceration has been the focal part of my work here. Some of that has been academic and scholarly work, carrying forward my work on plea bargaining, and borrowing and braiding together lessons from the civil rights movement and the labor movement. I've been trying to ask what would, what could, what might it look like to build collective defense among people facing prosecution. What would it look like if they were organized into something approximating a union, able to leverage their collective power? It's an idea that I wrote about in these two essays up here about police strikes and defendant unions, and one that I hope, after, God willing, finishing the current book that John and I are writing, to turn to in a future book told through the lens of the J20 prosecution, which to my knowledge is one of the most successful examples of collective defense in recent memory. But beyond scholarship and books and writing, the investigation of lawyering in service of organizing has been central to the advocacy and teaching that Premal and I do through the Institute to End Mass Incarceration, where our approach is pretty straightforward. We try to operate as something like the in-house counsel to grassroots anti-carceral organizers who are engaged in live campaigns against mass incarceration right now, today. We try to do the work. We try to model effective and responsible lawyering and service organizing, and we try to teach it to our students. In part, what we try to teach is that to do this work well, you have to reimagine what it is that lawyers actually do. As Gordon writes, the lawyering and service of organizing model sees law differently, as subordinate to and supporting of an organizing-driven theory of change. Litigation is useful insofar as it helps achieve organizing aims in ways that may be essentially indifferent to the outcome in court if the litigation is useful to your organizing campaigns for other reasons, whether that's to help craft narratives, to draw in resources, to gain attention, to gain information, to delay. It is an idea that Jules Lebel says flips the relationship between law and politics. Instead of politics shaping law, the goal is to use law to facilitate, bolster, amplify, and enhance political contestation, not abstractly, but in the context of real, live, organizing campaigns unfolding on the ground. I want to be clear, this isn't fluffy lawyering. You have to be really, really, really good at law to do it well, as the students in our clinic can tell you, now that they have become experts in the federal appropriations process, in eminent domain law, in restrictive covenants, in FOIA, in creative Eighth Amendment litigation. They've become excellent writers, excellent legal thinkers, more so even than they were when they came into the clinic. And they have to be incredibly flexible, because none of those topics were really about criminal law. They came in and they didn't expect that they were going to be taking a class where they're talking about eminent domain and property and all these other things, but that's what was required by the moment and the contingencies of the campaign. But always with the idea that it is, again, subordinate to a bigger picture, part of a broader political campaign, but not with law as the engine of the change itself. Part of this also, though, requires some reimagining the relationships between lawyers and non-lawyers engaged in the work. Gordon has written a really terrific case study of the legal department of the United Farm Workers Union. And one of the things she says from looking at that integration between lawyers and organizers is that getting that integration right is essential. You have to focus, she says, on the internal relationship between the organizers and the lawyers. And you have to try to avoid two competing pitfalls. On the one hand, the lawyers have to know how not to lean in too much, how not to dominate the space, how not to take over, most fundamentally, how not to clientize their comrades. And they have to know not to lean out too much. Because if they withdraw too much, if they basically just ask the organizers, look, you tell me what to do. Give me the tasks, I will punch through them, I'll file what you want, I'll do what you want, FOIA requests, you got it. They are depriving the organizers of their own knowledge and expertise, which is itself a really powerful resource. As Jessica Govea, an organizer with the UFW, says, you gotta have both. You need an organizer who's confident enough in their own skills and leadership to give room to the person coming in who brings in this different kind of knowledge. And that person coming in who brings that different kind of knowledge, including legal knowledge, has to understand that they're not the union president, but that they have something very important to offer, and they have to be able to offer it. In short, you have to have mutual respect among the lawyers and the organizers. And Gordon suggests you have to facilitate that with something like an in-house structure, which she said was hard to do. And she was writing in the context of a formalized union. I can tell you it is even harder to do when you're trying to build it within a sort of scrappy, organic, nascent, amorphous coalition of grassroots organizers. But that's a huge part of the work that we've been trying to do with the Institute. For the past year and a half, we have been integrated into and sort of fully interwoven into the organizing team leading a coalition that's trying to stop the construction of a new prison in eastern Kentucky, which would be the most expensive federal prison ever built. This has involved work along structure, figuring out how to create a space within this coalition where non-lawyers and lawyers work hand in hand to develop and co-own legal strategy. It's involved figuring out how to empower the non-lawyers to understand the complexities of law so that they can own the key decisions on how that strategy goes forward. And then it involves implementing the work, doing the tactical work, while always remembering that the law itself is not the engine of the change. This has also, though, led us to realize that we needed to do some work rethinking legal education. Because one of the things that Gordon says that really sticks with me is she says that these movements need attorneys who are also, not instead of, but also, sophisticated in their understanding of how law and organizing work together. It's what we've been trying to teach through the course that attaches to our institute, where we've been trying to have as one of our major goals, teaching students what organizing is. To me, describing organizing involves talking about how organizers use emotion and narrative to build motivation in the face of threats and hardships. And then how they reinforce that motivation and solidarity through real, concrete, strategic action, turning resources into wins. But most importantly, it's recognizing that it's concrete skills that make that work possible and doable. To put it another way, organizing is a practice and a craft every bit as sophisticated, as nuanced, and as teachable as lawyering. And that's what we've been trying to do. Working with Marshall around these different ways of teaching what organizing is, teaching students how to tell narratives that motivate others, how to build relationships that allow them to grow collective power, to structure those relationships into teams that can work effectively, to create strategies that leverage their power for change, and to take actions that implement strategy and grow resources. We've been at it for 3 years. It's a 24-hour course taught over 3 days. That's a requirement for everyone who takes the clinic. And over those years, we've had 75 hours of class time for 30 students. And this year, for the first time, we got to include students who weren't in the clinic, thanks to the Law and Political Economy program. And the hope that I share with Professor Bowie and a number of other professors who are here is to try to get this to something that's open to everyone at HLS. Because we think it's something that all of our students should be able to learn. And we know that it's something that so many of them want to learn. As Morgan Sperry and Devin Schill write, who are here now, Our students today are looking outside the court to build justice with staying power, and they are asking how lawyers might have partnered with organizers and built collective political and moral power to do it. And I think a leading law school has to be able to help them answer that question. This brings me to a few just final thoughts about the relationship between lawyers and the movement to end mass incarceration. Because I know that for some of you in this room, this will be your life's work. And to those of you already engaged in it, I feel so buoyed to get to do that alongside you. For many of you, your careers, your scholarship, your interests will take you to places where this is not your day job. But my closing thought is I want us to realize that all of us as public citizens can reflect on ways that lawyers and movements think about radical social change differently. Movements, as I've tried to suggest, are about the manifestation of radically obvious ideas, about trying to turn the world as it is into the world as it should be. Lawyers tend to focus on governance, on policy, on risks, and on the details of implementation, which is valuable. But these two things can also be in tension. If movements sing the songs of poetry, lawyers are more often writing the essays of prose. That's what makes us the life of a party. But as folks on the movement side of it will sometimes point out, they can sense in lawyers that it feels disturbing to push for the demands of social movements if you're approaching the problem within the existing order. To them, and I think here they might be talking about some of us, to lawyers, a movement like abolition is unworkably utopian and therefore not pragmatic. I think this boils down for many people to a pretty simple question when they're thinking about the pragmatics of all of this, which is, what about crime? And here I'd like to suggest that many critics of the movement to end mass incarceration get the movement wrong. Contrary to many assumptions, folks in this movement care greatly about safety. They care greatly about it as a basic human need and want more of it. As our own graduate, Derica Purnell, says, when people dismiss abolitionists for not caring about victims or safety, they tend to forget that we are the victims. We are the survivors of violence. As John and I write, it would actually be surprising if a society marked by systemic and structural racism did not see social harms concentrated among the most vulnerable communities, including the harms associated with criminal offending itself. This is tricky because everything that we know about the empirics of the relationship between crime and incarceration points in a complicated direction. First, we know, and the Council of Economic Advisors has confirmed for us, that prisons and police are the worst way to deal with crime. If you're going to spend an additional public dollar on something, they say spend it on everything else that we know works better. Invested in education, in public health, in housing security, in income security. They say more incarceration fails a cost-benefit test. At the same time, we also know that policing and incarceration decreases civilian on civilian criminal offending, including, again, in communities where crime itself is a manifestation of systemic injustice. Basically, you can think of carcerality like chemo. You wouldn't prescribe it to people forever, or encourage everyone to take it, or confuse it with a cure for cancer. And if you got rid of it right now, right today, there's at least the risk that cancer gets worse. All of which to me suggests that the movement to end mass incarceration is, at least in major part, about the practice of transitional justice. Something, again, that folks leading and working in that movement know well. Abolition is not, Ruth Wilson Gilmore and James Kilgore write, a fever dream demand to destroy all prisons tomorrow. Rather, it is, again, about trying to do two things at once: reducing harm while building responses to it that don't depend on carceral systems. That project can be a tightrope. You can fall off a million different ways on either side. And for lawyers, that can be scary, because the path across it is uncertain, the footing is unsure. But the thing that I would like to suggest to lawyers is that it is just as dangerous to stay put, to not try to walk across the rope. If you know that what things are on your side of the rope is the system of mass incarceration that we have today. This is why, for me at least, the poetry is just as important as the prose. Organizers are comfortable with the idea of being in the middle of a process without definitive answers. And it's important when trying to walk across that rope, I think, to listen to some of the things that they tell us. That even though the goal may be far away, if you don't name it and fight for it, you won't get there. And that the work to try to make radically obvious ideas real in the world, to make the world look like it should instead of as it is, always feels impossible until somebody does it. Thank you.
I think we have time for maybe a couple of questions, and then there is a reception to follow. So,
You leave me in the unenviable position of standing between people and wine.
encouraging you to be concise.
Yeah. You should have said that before the talk, John.
Questions? Not a shy button.
So this is great, and it should make people like me question life choices that we've made. And in that spirit, I guess when I hear you talk this way, when I hear others on our faculty sometimes talk this way, there's one way of taking it that's like, given that we're all lawyers and law professors, how can we best, turn that to the benefit of this problem? Okay, and you're making us maybe a strong case that better to do this kind of help the organizers than be a public defender. But there's a different kind of question, which is like, suppose you're not yet stuck in that constrained option set of like, you're a lawyer or you're a law professor, so like, how can we make the best of that? And like, suppose you just care about these issues, would you actually advise somebody who cares about these issues to become a lawyer in the first place? It seems like there's a more radical version of the radicalism that's like, it's not just do lawyering this way, it's like, maybe what we need is not lawyers.
It's a great question, Ben. It's basically the question that's the last session of our seminar, spoiler alert for folks in the clinic. One of the things we read is this letter from Dean Spade to a young person considering law school. And Spade basically says pretty strongly, I mean, not totally, but the answer seems to be don't go. And then we sort of read the other pieces of it. And folks who say, actually, look, social movements are myriad, diverse, and inherently draw their strength from that diversity, right? And what I'm trying to do here, I hope this doesn't come off as a don't be a lawyer talk, because I mean almost the opposite. If it's not clear, I love being a lawyer. I've loved every minute of being a lawyer. My mom would say I've loved being a lawyer since I was 5. I still love being a lawyer. The trick for me, Ben, has been figuring out how to do it in a way where that dissonance resolved into a key that didn't feel like banging the wrong notes on the piano. So what I'm trying to suggest with this lawyering in service of organizing is not to like try to erase the first part. It's lawyering in service of organizing. And by the way, that's itself just one of the models. Again, I'm not saying don't be a public defender. I tell students who come into my office all the time, they say, Professor Crespo, one thing about being a public defender. I say, I loved it. Sometimes I want to go back. I think the point is to tie it to my experience sitting in Tree's class and my experience sitting in Marshall's class. If you're lucky, you find a way to do your work that feels like a vocation. And law can be a vocation that is incredibly powerful in social movement work. So, I think Spade's point is well taken for folks who don't feel it as a vocation. And if you feel it, do it, and do it well, and do it in a way that feels moving to you and moving to others.
That's a perfect note from which to end, but we can't end quite yet. one more little thing we have to do. You'll never guess what is next to me here. I'm going to ask Andrew to do the reveal.
Oh, wow, okay. I feel like I should yell Toro.